Get ready for the dictation. Start. Aggrieved by the dismissal order, the appellant preferred an appeal under Section 164 of the Army Act before the respondent number 2 that came to be dismissed vide order dated 4th October 2001. The said orders were challenged by the appellant before the High Court of Judicature at Allahabad by filing a writ petition that was transferred to the AFT for decision and was finally dismissed by the impugned order. Mr. Shivkant Pandey, learned counsel for the appellant, seeks to assail the impugned order on the ground that the respondents have violated the provisions of Section 39B and Section 120 of the Act, that the SCM could not have awarded punishment of dismissal from service and the maximum punishment was of imprisonment for a period of 1 year, which could have been awarded, that Section 72, which deals with alternative punishment awardable by the court material, and Section 73 that contemplates a combination of punishments as a sentence of a court material as set out in Section 71 is not applicable to a SCM but only to a general court material or a district court material. And lastly, that Regulation 448 of the Defence Service Regulations 1987 prescribes the scale of punishment awardable by SCM, and in the table of punishments mentioned in the schedule, absence without leave or overstaying leave features at serial number 4, which entails a punishment of rigorous imprisonment for 3 months or less, whereas the appellant has wrongly been imposed such a harsh punishment of dismissal from service. It was thus argued that the punishment of dismissal from service imposed on the appellant was disproportionate to the offence committed. Per contra, Mr. R. Balasubramanian, learned senior advocate appearing for the respondents, refuted the arguments advanced by the other side and submitted that the appellant remained a habitual defaulter, which is apparent from the number of punishments imposed on him as set out in para 4 of the impugned order. It was argued that contrary to the assertion of the appellant that he had reported to his unit on 18th February 1999 but was not allowed entry as per the records, he did not report for duty on expiry of the extended leave, nor did he provide any documents to support his claim that his wife was so unwell and he was getting her treated. The allegation of the appellant that the procedure followed during the conduct of the court of inquiry or the SCM was contrary to the rules was wrongly refuted by the learned senior counsel, who stated that the court of inquiry was conducted under the orders of the respondent number 4 and there was no procedure prescribed for the respondent number 4 to have reported the matter directly to the respondent number 3 as contended. Learned senior counsel concluded by submitting that the appellant, having pleaded guilty of the charge during the course of the SCM, he cannot be permitted to renege subsequently and question the entire process. We have heard the arguments advanced by learned counsel for the parties and perused the records. The contention of the appellant that he was granted leave for the period between 8th November 1998 and 15th January 1999 and his request for extension of leave was unreasonably rejected by the respondents, whereupon he had returned to the unit on 8th February 1999, thus having overstayed leave only by 34 days is not borne out from the records. The appellant was granted leave for 39 days from 8th November 1998 to 16th December 1998, and his request for extension was acceded to up to 15th January 1999. When his request for further extension of leave was turned down by the respondents, the appellant ought to have reported for duty immediately on expiry of the extended leave, but he failed to do so. No document was produced by the appellant to demonstrate that he had reported to the unit on 18th February 1999. In fact, even in his statement made during the summary of evidence, the appellant failed to mention that he had reported to the unit on 18th February 1999. Quite apparently, this was an afterthought. In fact, in his statement, the appellant had clearly admitted that he left his home and came to Bangalore, where he surrendered on 3rd May 1999 after remaining unauthorizedly absent for 108 days. The appellant did not place any document on record by way of the treatment summary or medical certificate of his wife to demonstrate that she was seriously ill and required his presence for constant treatment. Instead, a bald statement was made by him during the summary of evidence to the effect that he had remained absent without leave on account of his wife's ill health. Moreover, the appellant failed to cross-examine any of the prosecution witnesses produced by the respondents during the summary of evidence conducted on 12th July 1999. Stop.